think we're live. All right, hello and welcome everyone who's joining us. This is the second of a three-part series on sex offender registration laws hosted by the NYU Review of Law and Social Change. Thanks for bearing with us. We had some technical difficulties, but now we are on our way. My name is Sandy Mayson. I'm a former public defender, currently a Furman Fellow here at the law school, and I'm very pleased to be moderating today's panel. As I said at the start of yesterday's panel, this is a difficult topic, but that's also why we think it's an important one. Sexual violence is a terrible harm. That's why we want to think carefully about the way that we choose to address it. Yesterday's panel introduced the subject of sex offender registration and notification laws and explored their impact on the lives of registrants and their families. In other words, the human costs of registration and notification regimes. To give a very quick recap, by the best available estimate, there are approximately 800,000 people on registries in the United States, a substantial portion of which were children when they committed the triggering offense. Offenses that can trigger registration range from rape to public urination, and registration and notification regimes themselves vary in scope from jurisdiction to jurisdiction. Most, though, have many components, and those can include requiring registrants to report in person on a yearly or monthly basis, to wear an ankle bracelet GPS tracker, and to send postcards to one's neighbors advertising one's release to the community. In addition, many states and municipalities have enacted residency restrictions that make it extremely difficult for people on the registries to find tenable housing. The social, psychological, and financial costs of these registration and notification regimes to people subject to them is profound. They're also, of course, tremendously difficult and expensive to operate. Given these costs, the question arises, do these programs work? The stated purpose of registration and notification regimes is to reduce rates of sexual offending. Do they? Presuming that they have some effect, is this the best way in a world of limited resources to address sexual harm? These are the questions that today's panel will address. I'm thrilled to introduce our three panelists who are experts in the field. Start. Tamara Lave is an associate professor at University of Miami School of Law.
It's actually Tamara.
I'm sorry?
Tamara.
Tamara. I'm so sorry.
It's okay. It's confusing, I know.
Tamara Lave is an associate professor at University of Miami School of Law. After graduating from Stanford Law School, she practiced as a public defender in San Diego for 10 years before obtaining a doctorate in jurisprudence and social policy at the University of California, Berkeley. She teaches and writes about criminal law with a particular focus on the punishment and control of sex offenders. J.J. Prescott is a professor at the University of Michigan Law School, where he co-directs the Empirical Legal Studies Center and the program in Law and Economics. He has conducted and published groundbreaking empirical studies of the consequences of post-release sex offender laws and has served as an expert witness in litigation involving the constitutionality of sex offender laws. More broadly, his research interests revolve around criminal law, sentencing, employment law, and the dynamics of civil litigation. Elizabeth Letourneau is an associate professor in the Department of Mental Health at the Johns Hopkins Bloomberg School of Public Health, where she directs the Moore Center for the Prevention of Child Sexual Abuse. For the past 25 years, Dr. Letourneau has conducted research on the evaluation of sex offender public policy effects, as well as the development and evaluation of assessment instruments and clinical interventions addressing youth and adult sex offending behaviors. She's published widely on these subjects and received numerous honors for her work. All right, this is a trailblazing online panel, which is another term for experimental, so please bear with us in the case of additional technical difficulties. Please also email us your questions during the panel. We'll be addressing audience questions at the end. And to give you just a brief sense of the shape this panel will take, we'll begin with some baseline statistics about the problem that registration and notification laws are designed to address. Then we'll move to the empirical question of how well they work. And finally, we'll close with a discussion of what we should do with the empirical data that exists to date. All right, to begin, we're going to begin with a discussion of the problem. So when people think of sex offenders, the popular image of a sex offender is the incurable child molester or the serial rapist. And the prototypical crime that people associate with sex offenders is this terrible crime of sexual assault of a child by a stranger. Tamara, how representative are these figures of the sex offender and this idea of sex crime? Can you give us an idea of how frequent this kind of crime is?
Sure. So first of all, I think it's important to note what you say, which is that if you look at national opinion surveys, most Americans think once a sex offender, always a sex offender, that sex offenders cannot be rehabilitated. So the first thing that's important to note is that sex crimes have been dropping since about 1992 into the present on every national measurement tool. So if you look at the Uniform Crime Reports, which is tracking rapes known to the police, rapes have been dropping since 1992. If you look at the National Crime Victimization Survey, which tracks rapes and sexual assaults that are reported to people who work for the Department of the Census, so they're trying to contact victims to deal with the underreporting problem, they find that rapes and sexual assaults have been dropping. And if you look at NCANS, which is looking at child abuse, which of course Elizabeth would know more about than I, researchers also think that sex abuse against children have been dropping as well since about 1992 on. So that's the first thing that's important to realize. And the second thing is that although, as you note, and as I said, what opinion survey shows, that most people think that, that sex offenders can't be rehabilitated. In fact, studies on recidivism, which is a fancy way of basically saying, you know, once someone offends, do they do it again? Studies on recidivism show that most sex offenders do not, in fact, reoffend. So there was a large study that was published by the Department of Justice in 2003, looked at 9,691 sex offenders released from 15 states across the country, and they found that 5.3% of sex offenders were rearrested for a new sex crime within 3 years, and 3.3% of child molesters were rearrested for a new sex crime against a child within 3 years. And let me just pause to emphasize, I'm talking about rearrest, not conviction. And then there's other studies that also show low recidivism rates. So most experts agree that recidivism rates are low. In addition, we know that as people age, just as with regular criminality, that as they age, they're less likely to commit sex crimes. That's true for rapists and child molesters. And we also know that the longer that people are out in the community not offending, the less likely they are to reoffend.
A quick follow-up, how do those rates compare to rates of recidivism among other offender groups?
So actually, sex offenders are less likely to so there's two answers to your question. The first question is recidivism in general for any kind of offense, and sex offenders are significantly less likely to be rearrested for any felony as composed with non-sex offenders. However, sex offenders are more likely to be rearrested for a new sex crime as compared with non-sex offenders.
Okay. And last specific question, do you have a statistic on what percentage of sex crimes are committed by a stranger?
So I'm sorry that I don't. I don't have an answer to that. I know that although the iconic image of the sex offender, in fact, JJ's going to find it right now for us, is policies driven by, you know, Richard Allen Davis, who kidnapped Polly Klaus from her window in Petaluma, California. That's why 3 Strikes was enacted in California. Those really highly salient, incredibly disturbing crimes drive policy, but in fact, most sex crimes are committed by people that know each other. Most are not stranger events.
Okay, great. Elizabeth, can you give us a similar picture with respect to juvenile sexual offending?
Sure, and I can say maybe about 10% of sex offenses are committed by strangers, whether we're looking at adult or juvenile offenses. The percentage varies, give or take a couple of percentage points, but not by much. So 90% are committed by acquaintances, friends, or family members. Juvenile recidivism rates for sex offenses are very low. The latest numbers, friend and colleague Michael Caldwell, who's published in this field over the same period of time that I have, tracks the recidivism rates of all new studies that are coming out. I think he's up to 89 studies, and he's seeing an average of about 5%. When I looked at data from an entire state across a 15-year period of time, I saw a rearrest rate of about 7% and a reconviction rate for a new sex crime of less than 3% over an 8.9-year follow-up, so almost a 9-year follow-up. So the vast majority of youth, once they're detected, do not commit a new sex offense. If they commit any new offense at all, it's far more likely to be some other kind of offense. And for youth, what we see is that kids who have offended sexually have the same likelihood as committing a new sex offense as kids who have committed other violent person offenses. And so there's not a clear distinction between youth who have sexually offended being at higher risk for a new sex offense compared to other youth who have engaged in violent non-sexual offending. But either way, the recidivism rates are very, very low, much lower than the general public suspects, and I think that bodes very well for what we can do with youth, both to address sex offending once it has occurred, but also to prevent it from occurring in the first place.
Great, and just a quick clarification for you both. These rates that you've been discussing, they're baseline rates without the existence of notification and registration regimes, is that correct?
Yeah, and well, I mean, yes, and they've been varying over time, as Tamara said, since the early 1990s, and other kinds of violent crimes have also been declining, but the declines in sex crime rates predate the declines in other kinds of violent crimes, and they predate the enactment of national registration and notification policies.
Great, and is that true, Tamara, of the stats you were relating as well?
Well, so this the DOJ study was looking at people released from '94 and following them up to 1997. So during that period, there were some registration laws, but many of the states did not have registration laws. So when we talk about our studies, when JJ talks about a study and I talk about some studies that were completed, that the fact that there's that states did not enact their laws at the same time allows researchers to study the effect of the laws, the impact of the laws on recidivism. So although some states had registration laws at the time, many did not, and as Elizabeth points out, the drop in sex crimes was starting from '92, and studies have been done on recidivism before that. And most studies, experts across almost all these studies find the same thing, which is that that recidivism is low. And in fact, Carl Hansen, who is one of the people that's been most influential in creating instruments to predict whether or not people are dangerous, he actually wrote in a paper that because recidivism is so low, the best prediction is that an offender will not reoffend.
Okay, wonderful. That's a great segue into the core of this discussion, which is how well do registration and notification regimes work. So let's begin with JJ. JJ, you've done comprehensive research. Do registration and notification regimes reduce rates of sexual offending by adults?
I mean, in general, the answer is no. You have to be careful, though, because we're talking about multiple types of laws here. So in my work, I focus on registration and notification regimes as distinct things, and they're designed to work differently, so it shouldn't be surprising if they do, in fact, have different outcomes. Registration is designed to keep law enforcement apprised of where people are, to allow law enforcement to monitor them, and in situations where a crime has been committed, to facilitate investigation. Notification regimes are very different. They're designed to bring the public into the conversation, to allow them to respond for better or for worse to the existence of a registered sex offender nearby. Okay? My work shows that there's some evidence that registration laws may be helpful. In other words, letting the police know where a sex offender lives may have some ability to reduce recidivism. It doesn't seem to deter any sex offenders who are considering, who've never been arrested before from engaging in sex offenses, or at least I find no evidence of that. But there is some evidence that registration laws can reduce recidivism. Notification laws, on the other hand.
JJ, just to clarify and make sure it's clear, when you say registration, you mean private registries maintained by police departments, not accessible to the public. That's right. Private registration. There's some evidence that it has the potential to reduce recidivism. Notification laws, on the other hand, I don't know of any study that finds any effectiveness here, at least reliably finds effectiveness. And in my own work, I actually I do find some evidence that the enactment of a notification law may deter somebody who's never been convicted of a crime in the first place. But in terms of controlling recidivism, which is the focus of these laws, there's no evidence of that. And in fact, it may cut the other way. Great. Thank you so much. Tamara, you're familiar with other research on this topic. Have other researchers come to the same or differing conclusions?
So other researchers are consistent with what JJ talked about. I'll just briefly mention two. One was a study that was published in 2008 by the New Jersey Department of Corrections. And of course, Megan's Law was named after Megan Kanka. And so New Jersey was interested in studying whether or not Megan's Law had an impact, had lowered the number of sex crimes in New Jersey. And they noted several things. First, they noted that sex crimes had been dropping during the period that Megan's Law was enacted in New Jersey. And they found, however, that Megan's Law had no impact on the incidence of, well, they had no impact on two things. First of all, no impact on the time in which, after someone was released from custody, they committed a new crime. That'd be a deterrence rationale. And they had no impact on the incidence of sex crimes. And they actually concluded, and I'm going to read the conclusion. So they concluded, despite wide community, let me pause to say they also looked at the cost of registration laws, because of course we live in a world of limited resources and we need to spend our money well. And they found that it cost the state of New Jersey about $700,000 to enact Megan's laws, the registration laws, and the notification laws, and they found that it costs about $5 million across the state to keep these registration laws going. And so they conclude, despite wide community support for these laws, there is little evidence to date, including this study, to support a claim that Megan's Law is effective in reducing either new first-time sex offenses or sexual reoffenses. And let me just pause to say this is the New Jersey Department of Corrections. So should future studies establish that Megan's Law has no demonstrable effect on the rates of sexual offending, policymakers and legislative leaders should investigate other options for lowering sex offense rates, such as mandated treatment for all sex offenders, potential use of polygraph testing, intensive probation and parole supervision. So I mentioned that study, and then there was a study that was conducted by Amanda Agan. It was actually published in the same edition of the Journal of Law and Economics as JJ, and Amanda was looking at the effectiveness of sex offender registries. She was trying to she looked at the effectiveness in three different ways. She first of all looked at whether or not the registries or notifications, so public access to the information, had an impact on the rate of rape in states that had notification laws. So she was basically looking comparatively, but with fancy statistics, at states with notification laws as compared with states that did not have those laws. She found that there was no impact on, she found no significant impact, no significant statistical impact on the effect of the laws on sex offenses, rape offenses in particular. Then she looked to see whether or not registering affected, so this is different than JJ, reduced the sex offenses, sex crimes of registrants, I beg your pardon. She did not find evidence to support that. And then she looked at whether or not you could, by using information where sex offender registrants lived, whether or not that predicted where sex offenses took place in terms of certain neighborhoods, and she found no impact, no evidence of that either. So she concluded that there was basically a pattern of non-effectiveness, and that she found that there was no support for the conclusion that sex offender registries were successful in increasing public safety and lowering recidivism.
So that sounds very unequivocal. JJ said he was unaware of any studies finding that public notification reduced rates of offending. Tamara, is there contrary evidence? Is there any data on the other side of this debate?
Well, I think what Amanda found is that, I think what she found was that there was no strong evidence to support. I think she found that that she was looking both at registries and public access, so she combined the two things together, and she found that did not that she did not find a significant decrease, but I think that what she found was a lack of evidence to support it. That's how I would characterize it. JJ could help me to say this in a way. I'm trying to kind of speak in a common person, not a fancy, JJ way, but they did have some contrast. Their findings were different, but I don't think that she found a strong finding that was different than JJ's. I think that she just did not find strong support for the rationale that the sex offender registries worked in the way that they were supposed to.
Mm-hmm.
Right, so it sounds like if there's any difference between JJ's conclusions and hers, it's with respect to the private registries, but they came to the same conclusion about public notification. Is that accurate, JJ?
I think that about sums it up. With empirical studies, you're dealing with different jurisdictions, which by definition have different laws. You're dealing with different sources of data. There are a lot of reasons, and Amanda and I, we recently published a paper together just this last fall, in which we kind of explore some of the questions that come out of our joint papers on these topics, and it really focuses on where sex offenders live and the risks, the geographical risks in those areas. Most people assume that if you live near a registered sex offender, you're more likely to be victimized. Turns out not to be true. But yeah, our papers line up about, I'd say 80% in terms of conclusions. And where we differ in largely based on potentially on data, but also on assumptions. So as Tamara pointed out, Amanda focuses on, in her work, Agan focuses on a certain kind of notification. So she focuses on online notification. My work with Jonah Rokov is more expansive. So it looks at other forms of notification, and in particular, active community notification, where sex offenders are required to send postcards, or even a police officer shows up at a door of a neighbor. So we're actually evaluating different policies here.
Got it. And JJ, am I right that you have actually concluded that public notification might lead to an increase in rates of offending? Yeah. If so, what's your behavioral explanation for that?
So I should say that in my work, our conclusion on that point is somewhat tentative, because it wasn't really the focus of our study, and one could imagine alternative explanations, although we spent a lot of time in the paper going through those alternative explanations, and none of them seem to pan out. But the basic claim here is, as an economist, I came at this from a general deterrence type of approach. So if I'm a sex offender who's been convicted, and I'm now living in a notification regime, how has my environment changed? And most people focused on the fact that, well, now potential victims know who you are, they can adjust their behavior, and that will make it more difficult for you to attack one of them. And this sounds quite credible on its face, but if you actually think about the underlying assumptions, it's not so obvious. So first of all, you have to assume that post-notification, there are a bunch of new individuals who are likely to be victimized, that are informed by this information. We've already covered the point that most victims of sexual offenses are known already, who are family members or friends of the offenders, so they might well already know of their criminal history. It also assumes that victims are capable of defending themselves, of acting in ways that actually reduce their exposure, and there's evidence out there to suggest that it's a mixed evidence that actually, even if you know that there's a sex offender nearby, doesn't really change your behavior, and so risk levels might not change, or may not pose much of a challenge to an offender. And finally, it assumes a certain way that sex offenders attack, right? So even if 80% of victims became aware, potential victims became aware of a nearby sex offender, that leaves 20% of victims, and so so at least under some ways of thinking about this, it wouldn't really be much of a challenge. Now, that means this is all to say that I'm not sure that the environment is all that much of a challenge to an offender who is at risk of reoffending. Now, what is driving them to reoffend? Well, all of this debate hasn't really focused on the advantages to an offender of trying to restrain or of trying to stay on the straight and narrow, to try to engage only in lawful activity. And a lot of that has to do with their ability to reintegrate into a community, to think, I don't want to go back to prison, I don't want to hurt anybody. But these laws, in addition to making it more difficult for offenders potentially to find victims, also make their lives miserable. So at the end of the day, if you think about what's going through an offender's mind, if the offender doesn't have a job, can't find good housing, can't maintain connections with family, has difficulty even walking down the street, you have to ask yourself, is the threat of prison for reoffending all that much of a threat? Another way of thinking about what these laws have done is essentially reduce the threat of criminal sanctions for recidivating.
Right. I mean, is it one way of saying it is that if there's nothing to lose, there's nothing to lose?
Indeed. And in fact, when we first started coming out with some of our research, there were some offenders who commented on blogs and the like that's exactly right. When you have nothing to lose, given how the world treats me when I'm out here, my life is miserable. Like, why should I be continuing to work so hard to stay on the straight and narrow? When actually going back to prison might not even be worse than what I'm currently living in. And we've kind of done that without realizing it. It was an unintentional consequence of enacting these laws.
Thank you, JJ. Let's turn to juvenile registration and notification regimes. Elizabeth, can you bring us up to date on the empirical data about the efficacy of those laws?
Sure. There are three groups that have done research on juvenile registration notification. Myself and my colleagues focusing on data from South Carolina until recently, and now we're doing some replication studies in other states. And Michael Caldwell, who I mentioned earlier, and then another individual, Ashley Battistini, and her colleagues. And the data here are clear and clearly consistent. Every single study that has been published on juvenile registration and notification finds no support for these policies. They do not reduce recidivism, sexual or otherwise. They do not deter first-time sex offending. And they are associated with unintended effects. And so what we found were, as you might expect, large increases in plea bargaining by these youth to remain off of registries. And so typically the case would plead from a sex offense to a non-sex offense, most often some sort of assault offense. And what we also saw, though, were large increases in dismissals and diversions. And so in South Carolina, which has a harsh juvenile registration law, which requires lifetime registration for almost every sex offense, with no possibility of getting off its lifetime no matter what we found was that many prosecutors were dismissing and diverting many more sex offenses after that policy went into effect. And then that increased after public notification went into effect. And then for cases that they did prosecute, the rates of plea bargaining increased, I think 150% from sex to non-sex offenses. So these are also unintended consequences that I don't think bode well for anybody. A youth who is convicted of an offense that's not a sex offense will not get sex offense specific therapy. A victim who has the wherewithal to come forward about an offense now stands a greater chance of seeing their case dropped or pled down to something that's not a sex offense, which I suspect is not a great message for victims. And then, of course, as JJ mentioned, these policies, I think it can be fairly said, make life extremely difficult for the people who have to live under them. One of the studies that we are conducting right now, my colleague Andy Harris and I, looks at the effects of juvenile registration on youth and on their parents. And the study's still ongoing. We have a small sample, but among older youth, young adults, 18 to 21, what we see is that those who are on registries or have been in the past report greater sense of hopelessness, lower sense of safety, more mental health problems, and so and economic difficulty finding and maintaining jobs. And so we see serious impacts on youth who are subjected to these policies, and zero impact on community safety, which calls into question not only their effectiveness, which there's literally no evidence of today, but then you can't have cost effectiveness if you don't have some sort of clinical effectiveness. You cannot have cost effectiveness if you have an ineffective policy, and so the money appears to be wasted. There is a cost study that's going to evaluate in a more consistent manner juvenile registration and notification, and I'm looking forward to seeing what the outcomes of that are. But from where I sit, where you've got maybe a half dozen studies published by various different researchers examining, I think, 7 state registries plus the federal Adam Walsh Act and the SORNA title of the federal Adam Walsh Act, and not finding any evidence of support, that type of consistency doesn't often happen, and I think it speaks clearly to the ineffectiveness of these policies.
Thank you very much. I want to take a moment to confirm with the panelists. Can all 3 of you stay, since we started 20 minutes late? Can you stay until 1:50?
I can.
I can too.
Yep, I just have to be off by 2.
Great. And to our audience, we hope that some of you can stay with us, and if not, the video will be on the web afterward. All right, so let's return to this empirical discussion. Elizabeth, the results you were talking about, do they incorporate residency restrictions? I'm curious, how do residency restrictions play into this picture?
So to my knowledge, there's no published research examining residency restrictions with youth. There are about 10 articles, again, give or take 1 or 2, that address residency restrictions with adults, and none of them find any support for these policies, and in fact, they've just been roundly criticized as completely ineffective. Other effects do occur, of course. So residency restrictions require sex offenders to live a certain number of feet or yards away from places where children congregate. They're often combined with places where children congregate can include schools, playgrounds, child care centers, daycare centers, in-home daycare centers, sometimes even bus stops. And they sometimes are combined with employment restrictions and education restrictions. And so we have quite a few studies and some very nice sophisticated studies using geographic mapping techniques to look at the rates of offending and where sex offenders have reside. And there's just no correlation between where an offender lives and whether he lives. I should say there's no correlation between whether an offender lives near a school or another place where children congregate and whether or not he's going to reoffend. Offenders, as I said earlier, mostly know their victims well, so they're not casing school grounds to find some kid that they don't know to take behind the bushes and rape. They are operating within their family and friendship circles, and so residence restrictions do nothing to mitigate the risk to youth. They do tend to cause sex offenders to congregate in close areas because there's so few places that an offender might have available to live in areas in jurisdictions that have residence restrictions. We know from delinquency literature that when you group delinquent people together, that has a bad effect. You have something called delinquency training, where more delinquent people will actually cause less delinquent people to up their game and to become more delinquent. So I've never thought that kind of housing sex offenders together or requiring them to live in such a small area that they are close to one another made a lot of sense. It also keeps them away typically from jobs and family members and all of the things that everybody needs to reintegrate into society. The other thing that residence restrictions does, besides make it difficult to find and maintain housing, employment, and relationships, the three keys to successful reentry, it drives down the housing market in the areas where offenders are allowed to live, which is, you know, kind of unfortunate for the other homeowners in that area. So this is a failed policy, I think, you know, at its worst.
Great. Tamara and JJ, is that the state of the research regarding residency restrictions and adult sexual reoffending?
Yes.
Yeah, I mean, there have been a few studies. I mean, it's hard to conduct these studies, mostly because information on where sex offenders live, historical information on that, is tough to find. But in general, the answer from studies that have looked at specific individuals and have, for example, you know, there's a study that takes a look at where sex offenders offended, given where they lived prior to the implementation of residency restrictions, and asked a simple counterfactual question. What would have happened with all of these crimes for this, I think it's between 150 to 200 convicted sex offenders? Would the residency restrictions have stopped these crimes from happening, or would they have interfered with these offenders going into those areas? And the answer is no, not a single one. So you combine that evidence with the evidence we already have on and what we know from your panel yesterday and from some of what we've seen today about the likely consequences of making life difficult for sex offenders, and at the same time asking them to stay on the straight and narrow and to try to try to reintegrate into society is a tough request. So.
Okay, on the basis of those reports, I'll ask one general question to all of you about the policy implications, which is just, should we get rid of registration, notification regimes, and residency restrictions altogether? On a cost-benefit analysis, which components of these, if any, are worth keeping? And Tamara, why don't we start with you?
Sure. So I would definitely scrap the residency requirements. I would get rid of the notification. I think that there's an argument, perhaps for some registration, but extremely tailored to only extremely dangerous people. But, you know, I'm reluctant to say that because the instruments they use to predict that aren't so particularly accurate. So I think that I would, I mean, if I ran the country, which I don't, I would get rid of it all. And I just want to pause to say, you know, I have an 18-month-old daughter who I love, and I can't imagine that anything bad would ever happen to her. And I understand that what drives these policies is anger and a sense that, you know, people deserve what happens to them. There are some people that don't care about people's lives after they are registering. They don't care that their lives are destroyed. They think that although they've done their prison sentences, that's not enough. That's not a feeling that I share. I think these people are still individuals and deserve a chance to thrive and rejoin society. But for the people that don't care, I think that if what they care about is lowering sex crimes and helping victims, these policies are not the right way to do it. I mean, these policies are extremely expensive. We only have so many resources, and instead of spending money in ways that would actually help victims and lower sex crimes, we're spending money in ways that don't work. So I'll just mention one, and I'm sure that JJ and Elizabeth will, you know, just add to what I would talk about. And, you know, when someone goes to the hospital and says they've been raped, a sexual assault response team kit, a SART analysis is done, and DNA is taken, semen is taken, if there's semen, blood if there's blood, and thousands of those kits. There was a 2009 study by Human Rights Watch, and they found that thousands of those kits are languishing because there's no money to pay for them to be analyzed. And so, you know, what does it mean? It means that we're paying, I mean, I told you New Jersey's spending $7 million a year on a program which is not effective, and yet we have all of these kits from people that report that they've been raped and aren't being analyzed, which means potentially dangerous people are walking around, and these victims have to deal with the fact that their crime is not being taken seriously by the criminal justice system. So I think that these policies don't make good sense, and for people that really want to help victims, this is not the way we should be helping them.
Okay, what about you, JJ?
Yeah, I guess I guess I don't know enough about these laws yet to say that we ought to scrap everything. I do think they're expensive. I guess my general reaction is residency restrictions seem to be a waste of time and money. The Eastern District of Michigan just declared some of Michigan's residency restrictions unconstitutional because they're just vague. Nobody can figure out what they mean. Not even the police know what they mean. So I don't see any that there's any value to putting money into enforcing those types of laws. With notification, I could potentially be convinced that there are certain individuals out there who have been convicted of certain crimes, and who may happen to be free despite having committed multiple violent sex offenses against strangers. I could be convinced that it might make sense for those individuals to let the public know that they are free. I haven't done any research on those, so I'm just speaking from my intuition, but I imagine there are some individuals out there who it might make sense to let the public know about them. As far as registration, I kind of think there's the big question has to do with the burden that is placed on registered offenders. So if you have to register, for example, and this is a private registry, so you're just letting the law enforcement know where you are. If you have to register every 7 days because you're homeless, that seems to me a bad idea, useless and really burdensome on the offender. I would think, on the other hand, that having the law enforcement know a little bit more about people's history than they otherwise would, and to make it easier for them to find them for investigative purposes isn't the end of the world, as long as they're not so burdensome that people can't hold jobs. All right. The last thing I would say is I've tended to come at this not from the perspective that it's not fair or that these are that sex offenders are people and we ought to treat them as people. I mean, I have my own views on that subject, but the argument really has to do with, and what people, or at least a lot of people care about, is just the public safety questions. And so the big question for me has always been, do these things make us safer? Do they not matter, or do they make us less safe? And I think actually, when you spend time looking at the data and you spend a little bit of time thinking about it, you're just compelled to the conclusion that either they don't do anything or they make us less safe. And as a consequence, we're essentially making people feel safer by doing something that makes them less safe, and that's just that's just bad policy.
One quick follow-up for you before we get to Elizabeth.
Sure.
Your data support the thesis that registration and notification regimes would be more effective if they were limited to a group of, as you say, people who had committed multiple serious sexual offenses?
I mean, it's consistent with that. I mean, unfortunately, I don't know. I mean, at least in my work with Rockoff, we don't know the nature of the offenses of the offenders who are committing the offenses that we study. So I can't say that for sure, but it does appear that more narrowly tailored notification regimes tend to be operative in states that have fewer sex offenses occurring, all else equal. In other words, strangely, the larger your notification regime is, in other words, the scope, the larger the scope is, the more sex offenses that tend to occur in that state, and that's after controlling for all the other things that you might think would make those two things correlated. And so one inference from those facts are that, yes, a narrowly tailored regime would be effective.
Great, thanks. Elizabeth, to you.
When it comes to youth who are sexually offended, I think they should be protected from registration and notification. I think it should be illegal to apply those policies to youth. There's no demonstrated value whatsoever. There is demonstrated harm. And so that would be my ask. That's a non-starter in most jurisdictions. And so the second that not being possible, the next step down I would say is to eliminate notification for youth, to eliminate all of the collateral consequences of registration that include residence restrictions, employment, and education restrictions. And if you feel a youth is so dangerous that he needs to register or she needs to register, before that happens, provide them with free or affordable evidence-based treatment. We have 3 randomized controlled trials demonstrating the treatment effectiveness of a family-based therapeutic intervention. Give them access to treatment, and if they do well in treatment, then there's no need to register. And if they do not do well in treatment, then I would say limit registration to the period of time of active supervision, so the period of time of probation or parole for a youth, and then it ends altogether. So to reiterate, I would say that we should not be applying any of these policies to youth who are adjudicated as minors of sex crimes. If that's a non-starter in a jurisdiction, then I would severely eliminate notification and the collateral consequences of registration, and limit registration only to those youth who fail treatment, and then only apply it for the period of time during which they're under active supervision.
May I clarify one thing?
Certainly.
So just to be clear, I think, JJ, I was not saying I would scrap everything. I said that I would scrap the laws on where people can live.
Okay.
Yeah.
Oh, that's fine.
Elizabeth's last discussion of treatment for juveniles does raise an interesting question, which is if this ultimately is a question of resource allocation, and Tamara, you pointed out that even for people who are concerned and solely concerned about public safety, this is not the most effective way of allocating dollars. You suggested we should be focusing on testing all of the rape kits that are languishing untested. Are there other alternatives? Are there treatment regimes for adults that are demonstrably more effective at preventing sexual reoffending?
Yes. And there was a time when sex offender treatment for adults was not shown to be very effective. There have been studies of recent treatment, or more recent studies that have shown that treatment can in fact be effective. So certain kinds of cognitive treatment, for instance, are effective. So I think that treatment can be effective. Certainly having more intensive probation and parole supervision can be effective. I have to say, just some straightforward policing can also be effective. There was an extremely disturbing case of a rape and murder in San Diego of a girl named Chelsea King, and she was raped and murdered while she was running at a place called Lake Hodges, where a lot of people used to run. And it turned out that a few months before then, there was a woman who was attacked, and she fought off the attacker, and she went to the police, and she had blood from the attacker on her. She told the police that this person had tried to rape her. The person told her that he was going to kill her, and the police never analyzed it, and they also never put any signs up at Lake Hodges warning runners that it was dangerous. They never contacted local high schools and colleges letting them know it was dangerous. So, I think that part of what's dangerous also about the registry is I think that they can make people feel falsely secure, not pay attention to people that they know who are dangerous, and they can. Well, I think that the police conduct in that was, I don't know whether part of it was they just thought because there were registries, people would be protected. I don't know, but you know, if the police had done their job there, it would have been a different outcome.
JJ, do you want to add anything to the question of resource allocation and effective alternatives?
I don't think so. I think that was great.
Okay, wonderful. I have myself one more technical question about your empirical research, which is to what extent are you able to parse out the effects of registration and notification by offense category? You know, for people who are registered on the basis of public indecency versus statutory rape versus serious sexual assault.
Right. So unfortunately, at least in my study with Rockoff, we're limited by the categories that exist in the National Incidence-Based Reporting System, and there is actually a fair number. There's a breakdown into forcible rape, into child molestation, and then into other crimes. And in some of our work, we actually look to see whether or not notification and registration have different effects on these crimes, and we might think that we might see a different pattern if there were changes in reporting behavior, which is one of the sort of potential concerns with these kinds of studies, because after all, we don't actually, at least when we're dealing with crime reports, the existence of a crime report usually requires both a crime and the decision to report it, and so laws may affect both of those things. And at least in that work, we didn't see much of a distinction. In some other work, this paper that I mentioned with Amanda Agan in fall of 2014, we actually used, in Baltimore County, we actually looked at police level offense records, and we did see that notification, at least in terms of identifying risk within a particular neighborhood, did see some evidence that these laws differ in their consequences based on the type of offense you're interested in looking at. And so, I can say more about that. But I do think it's incredibly important to pay attention to the type of crime we're talking about. I mean, certainly one of the obvious ways we can move forward in terms of reform is to shrink the list of sex offenses that are currently included. I mean, you can find states out there that include crimes that are hardly sexual by any normal definition. For example, I mean, an obvious one that a lot of people mention is urinating in public. Okay, fine, it involves exposure, but it's not a crime that I think most people would think of as a sex offense. And so when we're thinking about reforming these laws, we might want to think very carefully about what kinds of crimes do we think ought to define a sex offender, because once you put that label on people, people of course assume the worst. All right. So.
Thank you so much. That's a great segue to tomorrow's panel, which is about priorities and strategies for reform. I hope that everyone watching today will join us. Before we close, a last question for all three of you. You've been fairly uniform in reporting the results of your empirical research and others. There seems to be such a disconnect between the data and the rhetoric. What needs to happen for your work to make it into the public sphere and ultimately influence policy?
So may I just, okay, so I want to actually use my time to sort of add on to what JJ was saying.
Sure.
If we're going to have registration laws, which I think they're going to stay because of the politics behind them, I think we want to be rational about them. So I do think it would be smart to think about the kind of laws that deserve to have that, public shame, everything associated, the scarlet letter associated with it. And then we want to pay attention to what we know about the kind of factors that lead towards, to recidivism. So we know that women, for instance, have an extremely low rate of recidivism. We know that incest is a very low recidivism crime. We know that as people age, they become much less likely to reoffend. We know that as the longer people are out, they're much less likely to reoffend. So we should have registries that are tailored to that kind of information. And it would be helpful for the police, because if the police, ideally, if they have this information, they want to use it. And if they have information on 500,000 people, how is that going to help them? It's too much information. So for law enforcement to be more effective, we need to make sure that the registries are more carefully tailored to people who really are dangerous.
Thank you so much. Elizabeth, do you want to answer the question or add on to that?
You have to repeat the question for me.
The question was, there seems to be a profound disconnect between the data we have and the rhetoric and policy.
Yeah, so I'll say this. I think that disconnect is diminishing. And so in the juvenile world, there have been several state Supreme Court cases that have ruled in favor of rolling back juvenile sex offender registration notification laws, and the research is getting cited in those decisions often. There are state legislatures that are considering changing their policies to their juvenile sex offender registration notification policies. And so I think that there is, and in states, there's 38 states that on the books have juvenile registration, and fewer, but still plenty that have juvenile notification. But when you go and look at how those states are implementing their registration policies, many more now are implementing along the lines of Oklahoma, which has a juvenile registration and notification policy on the books, but only subjects youth to registration if they fail out of treatment, and they bend over backwards to make sure kids don't fail out of treatment, the result of which is they register one kid every 3 years. I'm running a study right now, as I mentioned, where we're looking at the effects of registration and notification on youth. So we're looking for kids who both have registration requirements and kids who don't to compare them with. And I can't find kids that are registered, in part because so many states now are fashioning ways for kids to avoid these requirements. And so I think through the courts, through state legislatures, and just through implementation changes, the lay of the land is much, much better right now for youth than it was 5 years ago. And my hope is that that will continue to be the case as we get more and more data supporting the fact that these policies really don't seem to do anything but harm. So, yeah, I think it's a little better than it might appear at face value.
I'm sure that is thanks in no small part to your work.
I don't know.
JJ, do you have anything to add on this last question or follow up to what the other panelists have said?
Sure, I'll just say one thing. I think that I do think the politics are really tricky here. A year or two ago, we expanded the registration regime in Michigan because a legislator said, "Oh, I noticed that we actually had some sex offenders that we weren't including on the list, and those might be dangerous. So why not expand it?" And that's really all that it takes to expand these laws. I think the dynamic has changed a little bit, though, in terms of incorporating research because the courts are becoming more involved. And so even if it's not politically palatable for a legislature to remove these kinds of restrictions or to change these laws in a way that might work better, courts can help them by striking down parts of the laws that are particularly ineffective or particularly punitive. And once they do that, the legislature is forced to go back to the drawing board, and the hope would be that what's produced out of that second go-around would be more thoughtful. But we'll have to see how that goes.
Well, that's an optimistic view ahead. With that, we'll conclude the panel. I want to thank our fantastic panelists and the NYU Review of Law and Social Change for undertaking this innovative panel series. Thanks in particular to Olivia Scheck for organizing the panel. We hope you'll tune in tomorrow at 12:30 for the last in the series, which is a panel about priorities and strategies for reform. Thank you so much. Have a great day.
Bye. Thank you. Bye.
Hang up?
I think we're still live.
We're live. I'm going to hang up now. Bye, everybody. Thank you guys so much.
Bye.